You're watching The Legal Breakdown. Glenn, we've got some urgent news here. Can you explain why Merrick Garland should actually dismiss the ongoing case down in Florida? This is the one where at least two more of Trump's co-defendants, Walt Nauta and Carlos de Oliveira, are still pending prosecution at the hands of the DOJ. So this does seem kind of antithetical. Why should the DOJ, before Donald Trump takes office, dismiss this case?
Because, Brian, it may be the only way to ensure that the evidence that was amassed by Jack Smith, that's included in Volume 2 of his special counsel report, the evidence of Donald Trump's unlawful retention of classified documents, his obstruction of justice, and his violation of our nation's espionage laws, dismissing the case against the two co-defendants may be the only way to make sure that evidence is protected and preserved from Donald Trump's Department of Justice. Because come Monday, if it hasn't been protected, if it hasn't been preserved, what do you think Donald Trump is going to have his DOJ officials do with evidence that incriminates him? Probably not preserve it for future use. I'm going to go out on a limb there. And so right now, this case is like in the legal upside down. Today, there was a hearing in a courtroom in Florida presided over by none other than Trump-appointed Judge Aileen Cannon. She was presiding over a matter in which she had no jurisdiction and no authority. And by way of background, Jack Smith generated a report about both of his federal criminal investigations into Donald Trump's crimes, his election subversion crimes in D.C., that was a case presided over by Judge Tanya Chutkan, and his classified documents crimes in Florida, presided over until she dismissed the case by Judge Aileen Cannon. Jack Smith generated a report that has two volumes, Volume 1 about the D.C. crimes, Volume 2 about the classified documents crimes. And Judge Cannon just decided to take jurisdiction over both of those matters. Mind you, she never presided over the election subversion crimes in D.C. Nevertheless, she temporarily put a stop to Merrick Garland publicly releasing Volume 1. That issue was litigated, even though she had no jurisdiction. So prosecutors should have told Judge Aileen Cannon, just talk to the hand. You have no jurisdiction over Volume 1, Donald Trump's D.C. crimes. But instead, they played along and pretended she had jurisdiction. Well, finally, they convinced her to release the hold, the prohibition. And we now know, as of Tuesday, Merrick Garland publicly released Volume 1, which pretty meticulously documents Donald Trump's efforts to try to steal the presidency, to try to overturn the expressed will of the American voters. But then Merrick Garland said, you know what? I'm not going to release Volume 2 publicly. Why did he say that? Because Donald Trump's co-conspirators, Walt Nauta and Carlos de Oliveira, are still involved in litigation in the appeals court, and they could face trial in the classified documents case in the future. So I think appropriately Merrick Garland said, so I'm not going to release that publicly, but I will give it to the bipartisan leadership of both the House and Senate Judiciary Committees so they can fulfill their important oversight responsibilities. And Judge Cannon, again, Brian, and I'm going to say this repeatedly, having no jurisdiction, no authority in the case, told Merrick Garland, not so fast. I am prohibiting you from releasing it to Congress. I'm basically interfering in this relationship between the two other co-equal branches of government. And I'm going to set a hearing on this matter, the release to Congress, for when? Friday afternoon, the last business day before Donald Trump is sworn in. So I was steaming a couple of days ago. I wrote a piece about all of this, which posted yesterday, addressing these concerns I had. Frankly, my fear was that if she was holding her hearing on Friday afternoon, do you really think you're going to get a prompt, oh yeah, I agree with the prosecutors, release it to Congress, all of the incriminating information about Donald Trump? I thought she might delay her ruling until after Donald Trump is sworn in and his DOJ officials could get their hot little hands on the evidence that incriminated their boss, Donald Trump. But it looks like we might not even have to wait, because the reporting coming out of that courtroom in Florida, this from ABC News, makes it look like it's even worse than Judge Cannon delaying her decision. Judge Cannon in court suggested it would be premature to allow congressional members to see the report, Volume 2, while the Justice Department continues to appeal the case against Trump's former co-defendants, Nauta and De Oliveira. And then she said this, quote, "There's really no way this court can do anything or enforce anything about leaks. What can I do if somehow this report gets leaked?" Well, here's what you can do, Judge Cannon. Nothing. Zero. Nada. You have no jurisdiction. This is not your business. It's not in your court. You have no authority. So now, that is probably the world's longest run-up to a direct answer to your question, Brian. Why should the Department of Justice right now consider dismissing the cases against Nauta and De Oliveira? Because it
I'm gonna amend that question a little bit, knowing that Donald Trump's DOJ in just a couple of days is going to withdraw itself from this very prosecution against Walt Nauta and Carlos De Oliveira, and B, knowing full well that Judge Cannon wouldn't let it go through, even though she has no jurisdiction. So you have no future in this case regardless, and so long as it's being appealed, that means Judge Cannon has decided that she has jurisdiction over it. So why don't we pull it out of the hands of Judge Cannon? Why don't we pull it away from a DOJ that's going to ultimately not be able to prosecute this case in a couple of days anyway, and just get this thing out of the court system so that Merrick Garland has carte blanche to release it?
That's what should be done. Desperate times call for not desperate measures, but very forward-leaning measures. As you just said, we know the cases against Donald Trump's two co-defendants are going to go away in a Trump Department of Justice. Let's, cut it off at the pass. Let's move to dismiss it right now, and let's release the report not only to the bipartisan leadership of the House and Senate Judiciary Committees, but you can release it publicly once the cases against De Oliveira and Nauta are at an end and can't go to trial if they are dismissed. And then we can all see Volume 2 documenting Donald Trump's classified documents crimes. Here's the thing, Brian. In order to do that, let's assume Merrick Garland, as we speak, is having prosecutors draft the motion to dismiss the cases against Nauta and De Oliveira. That motion still has to get filed. The court has to act on it. They would have to grant it. And as of right now, Judge Cannon's order prohibiting the release to those two congressional committees is still in place. So can we envision Judge Cannon maybe taking her dear old time getting around to the government's motion to dismiss, I don't know, maybe till about 12:01 p.m. on Monday? I'm not saying all hope is lost procedurally. There are some hurdles to overcome, but I'm with you. Let's dismiss the cases. They're going to be dismissed anyway, and let's make sure Volume 2 is protected, is preserved, and is publicly available so it can be used in the future. Why would we want to use it in the future? Because Jack Smith dismissed the case against Donald Trump without prejudice, which means, at least theoretically, it can be reindicted and prosecuted when Donald Trump leaves office.
Glenn, I presume you're not going to be able to answer this question, but why on God's green earth are they humoring this idea that Judge Cannon has jurisdiction? I mean, if I came in and said, by the power vested in me by virtue of being a YouTuber, I prohibit you from releasing this report, that would have as much weight as a judge coming forward who has no jurisdiction because it's not in her court anymore. It's in the 11th Circuit Court of Appeals. She has no jurisdiction over this thing. So it's bad enough that she tried to pull this stunt, but why are they humoring her by just saying that her rulings carry weight?
Yeah, why not let a Starbucks barista exercise jurisdiction over the case? At least we'd get a good cup of coffee. No, here's the answer, and I actually think I have a somewhat informed answer, and I'm not pushing the piece I just wrote and posted, but I take this issue on directly. But, first, I always talk to my friends who are the deep thinkers and the really accomplished appellate scholars. So let me just read one sentence from my friend Joyce Vance, who really is a preeminent appellate practitioner when she was a federal prosecutor. She said that the strangest thing about this entire proceeding is that Judge Cannon continues to issue orders when there is no case pending in front of her. That's not how a court's jurisdiction is supposed to work. But let me answer your question, Brian. I used to fight these battles when I saw judicial overreach, which I saw on a handful of occasions in my 30 years as a prosecutor, not to this extent, this extreme extent that we see from Judge Cannon, but I did see judges overreach, maybe put their toe over a constitutional line or a separation of powers line. I would go to my superiors at the Department of Justice and I would urge them to let me take up the fight, because you don't want to give in to judicial overreach. When you do, when you decline to fight that righteous fight, we have a term for it. We call it feeding the monster. You don't feed the monster. You fight the monster. You starve the monster. You may win the battle, you may lose, but you have to fight because it's the right thing to do for the integrity of the criminal justice system. I'm going to tell you, Brian, more often than not, I couldn't get approval. I couldn't get approval from the higher-ups of the Department of Justice. Why? Because they knew that we would have to see that judge again and again and again and again in future cases, and they didn't want to antagonize and potentially alienate the judge. So often, we would feed the monster rather than fight the monster.
But in this case, it's not like Judge Cannon is some judge who the DOJ is going to go in front of in the future and we need to preserve some relationship because this is some neutral arbiter of the law. She is like an extension of the Republican Party. Any Democrat is going to lose to her 10 times out of 10. And so what's the worry about antagonizing someone who is basically Jim Jordan in a robe at this point?
Well, there's no concern from my perspective. I know what I would have done. But doesn't this course of conduct by the Department of Justice have echoes of Jack Smith's decision never to seek to have her removed because her impartiality could reasonably be questioned, which is the legal standard to have a judge be required to remove themselves from the case? Do you know, Brian, if we had successfully moved to recuse or remove Judge Cannon from presiding over this case ages ago, you know, this case would have been tried. It would very likely have resulted in convictions. And because these crimes were committed by Donald Trump after he left office, no presidential immunity would have attached, and we wouldn't be here today.
Yeah, that is just, that right there is the perfect distillation of the consequences of a neutered DOJ, neutered prosecutors, people who are more focused on the optics of politicization than actually upholding the law. And sadly, that is what we're left with. And I hope that the lesson that comes out of this thing, because at this point, that's all we're left with, the lesson that comes out of this thing is that we gain no wins by virtue of conferring goodwill to Republicans. It will never be reciprocated. This idea of good governance will not redound to our benefit. And our best bet moving forward is just to be aggressive in upholding the law and to recognize that lawlessness begets more lawlessness, and our inability to actually attack this stuff head on only makes the Donald Trumps of the world even more emboldened to commit more crimes moving forward. So I hope that's the lesson moving forward.
And Brian, this is not rocket science. There's an easy fix for all of this. You apply the law without fear or favor, particularly without fear of criticism that what you're doing is politically motivated, because it's not. You know, I keep hearing everything in these confirmation hearings of, for example, Pam Bondi, who's been nominated to be Attorney General. You can't go after your political opponents. You can't go after your political opponents. Whoa, 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 whoa. What about if your political opponents are committing crimes, violating the laws of our nation, victimizing the American people? Should we be so afraid of criticism that we're going to let them run roughshod over the citizenry? Are you shitting me? That's a legal term.
Well, again, from your lips to the ears of the folks at the top of the Democratic Party moving forward, and hopefully, my only hope in all of this is that it's not too late. With that said, we will of course stay on top of any legal news as soon as it breaks, and hopefully, we'll see some last-minute action by the DOJ to actually have this report released. I'm not holding my breath. I would presume that you're in the same boat as me, but that doesn't mean that we can't beat this drum up until the very last minute. Again, for those who are watching right now, if you'd like to follow along with more legal news moving forward, please make sure to subscribe. The links to both of our channels are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.